Hello and welcome to HR Talk, People Management's regular discussion about the topics making the news in the HR world. I'm Jill Evans, and this week we'll be looking at whether higher costs awards in employment tribunals will actually deter claimants from bringing what are known as weak or vexatious claims. I'm joined this week by Aron Pope, who's a solicitor in the employment department at law firm Fox Williams. Aron, can you tell us about the case, please?
Yeah, certainly. The case was Smith and Pertemps. A very interesting case heard earlier this year. Smith was a director at Pertemps. She managed a part of the business which wasn't performing. As a result, she was asked to take a pay cut. She wasn't happy to do that, even though it was only on a temporary basis until performance improved. Pertemps subsequently dismissed her. She brought claims for sex discrimination, for victimisation and harassment. The tribunal, when hearing her evidence, didn't find her a credible witness. In fact, they said that she exaggerated her claims. They thought that she had rewritten the past history. As a result, Miss Smith lost her claims. They were all struck out, either because they were out of time or because the tribunal thought they were false claims. On the back of that evidence that she'd lied to the tribunal and the claims had been struck out, Pertemps applied for a huge cost award, and they were awarded £100,000 of their legal fees to be repaid by Smith.
Right. Why don't cost awards like this occur more often in tribunals?
Well, the position is that cost awards are generally seen as the exception rather than the rule, and that's based on a case called G and Shell. And although it doesn't mean that the case needs to be exceptional for costs to be awarded, there are only limited circumstances in which costs are awarded. So it would be where someone doesn't comply with a practice direction, or if they postpone a hearing, or if they bring a vexatious claim, if they act unreasonably during the proceedings or disruptively, or if they bring a misconceived claim, which is essentially a claim that has no reasonable prospects of winning.
Earlier this year, the government launched consultation on resolving workplace disputes with the aim of speeding up the tribunal process and encouraging employers and employees to settle cases without going to a tribunal. One proposal in that consultation document was to double the limit on costs awards from £10,000, the current limit, to £20,000. Aron, what effect do you think this proposal would have if it actually makes the statute book?
Well, we've conducted a survey, an online survey of clients and contacts through our website HR Law, and the response from our clients and contacts was overwhelmingly in favour of a number of the proposals. Some of the most popular ones were asking claimants to pay a fee before they submit their claims, and others involved increasing costs, as you said, and I think we had about 60% favour rate for increasing costs. The increase in costs from 10,000 to 20,000 is only in respect of unassessed costs. What happened in the Smith and Pertemps case was actually that the parties agreed outside of tribunal how much the costs would be, and Smith agreed to pay 100,000. Otherwise, it would have been assessed by a third party, and my understanding is that Pertemps' costs were multiples of 100,000, so Smith may have got off lightly in agreeing to 100,000.
Right. And is there always scope for employers to do that with people that are bringing a claim to settle outside the tribunal at a cost level above that set for tribunals?
It depends on the way that the hearing is structured. Often if there's a break between the merits hearing, which is where they decide whether or not the claim is successful or not, and then the quantum hearing, which is where they decide how much money is to be paid by the losing party to the other. Where there's a break between the two hearings, there's an opportunity to do a deal, and I suspect that's what happened here.
Are there any simple steps that employers can take to head off weak and vexatious claims before they get to tribunal, unassociated with cost awards?
Yeah, absolutely. I mean, the obvious answer to that question is don't make things easy for the claimant. So have good policies and procedures in place. Give your staff training on equality and diversity. If you are taking someone through a dismissal process, actually do follow a procedure that complies with the ACAS code or with statute or case law. Also, where you do dismiss someone, make sure they're given a fair reason for the dismissal. If you don't give them a reason, then they're likely to think that their dismissal is discriminatory. Then, in terms of the litigation itself, I think it's important that employers pick and choose which claims they're going to fight. So, for example, some claims are probably better off settled and dealt with quietly, whereas others, the employer needs to send the message to their staff that they won't be forced into settlement. I know that some of my clients are concerned that if they don't fight the odd case, then a number of employees will bring spurious claims in the hope of getting a payout. Then obviously if you are unfortunate enough to end up in litigation, there are steps you can take. So, for example, you can threaten costs at an early stage if the claim does appear to be weak or a spiteful, vengeful case. You can also ask the judge to award a deposit order, which essentially requires the claimant to pay money to the tribunal before they can carry on with their case. And finally, go for a pre-hearing review. That's a preliminary hearing where you might get the claims struck out. They tend to only last a day or so, which can be a lot shorter than a full hearing, which often run on to 2 or 3 weeks.
Thank you. Aron, thanks for joining us today. And if you want to know more about this topic, go to peoplemanagement.co.uk. And until next time, goodbye.